Hello and welcome to the webinar, Selected Issues Impacting Biopharma and Medical Device Patent Post-Grant Review Proceedings. My name is Whitney Bailey and I will be in the background answering any Adobe Connect technical questions. If you experience technical difficulties within the Adobe Connect session, please use the Q&A box on the right-hand side of your screen and our technical assistance team will help you in any way possible. If you are having issues hearing over the phone, you may press *0 and an operator will assist you. Please note that as an attendee, you are part of a larger audience. However, to maintain privacy, the number and names of attendees will not be displayed. All attendees will be in listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. We will be holding Q&A session at the conclusion of today's presentation. To submit a question, click on the Q&A panel located on the lower right of your screen. Type your question into the text field and hit send. Please keep the send to default as all panelists. This seminar is accredited for 1 hour of Illinois NCLE credit. Please inquire if you wish to seek CLE accreditation in additional states. During the webinar, we will be providing 3 CLE codes. Please write these down. We will be emailing evaluation forms at the end of the webinar and will ask for the codes. If you have questions regarding CLE, please contact cle@brinksgilson.com. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce our moderator for today, Jason Schigelone. Jason, you now have the floor.
Thank you very much, Whitney. I'd like to welcome everybody to our webinar. Again, my name is Jason Schigelone. I'm a shareholder and chair of the Medical Device Practice Group at Brinks, Gilson & Leon. I will be moderating today's presentation. Today's event reflects a collaboration between several of the practice groups at Brinks, Gilson & Leon, including the firm's Post-Grant Patent Practice Group, its Biotechnology and Pharmaceutical Practice Group, and its Medical Device Practice Group. With me today are 3 very talented attorneys from our firm, Joshua James, David Bernard, Andrew McElligott. Each of these attorneys will be presenting on a topic impacting post-grant review proceedings relating to biopharma and medical device patents. First, Josh will discuss joinder issues before the PTAB and how joinder can result in the board delaying issuance of its final written decision. Next, David will discuss Article 3 standing issues that could prevent certain parties from appealing adverse PTAB decisions to the Federal Circuit. Rounding out the program, Drew will discuss the Federal Circuit's recent In Re Aqua decision and how this decision impacts amendment practice in post-grant proceedings. After the presentations, we'll take questions from the audience. Without further ado, I'll turn the podium over to Josh.
Thanks, Jason, and welcome everyone. I'm going to get us started by talking about a recent trend in IPRs and other post-grant proceedings where it appears that joinder causes final written decisions to issue more than 1 year after the date of institution. We'll start off with a little bit of background information to make sure we're all on the same page, looking at an IPR timeline. After a petition is filed, within 6 months, the PTAB will issue a decision on whether or not to institute the IPR. If institution does occur, a final written decision is then required by statute to issue within 12 months. That final written decision deadline can be extended by no more than 6 months, according to statute, but thus far the PTAB has been very reluctant to do this, and therefore IPRs have typically been quite predictable. You know, once you have your filing date and then once you have your petition date, exactly when that final written decision should come by, either 18 months from filing, and then if you're successful with institution, 12 months from that institution date. If we're going to look at how joinder may be affecting that deadline, it's helpful to have a little bit of background on joinder as well. Commonly, joinder occurs where another party takes the initially filed petition, copies it, and creates what's called a copycat or a Me Too petition and files that along with a motion for joinder. This commonly happens for pharmaceutical IPRs where a first filer may file a petition, and if that petition is instituted, then the other generic pharmaceutical companies who are part of that case will file a Me Too petition and a motion for joinder to protect their interest in the case and to make sure that the IPR proceeds even if that first filer were to settle. Joinder can occur no later than 1 month after the institution date of any IPR. So looking at the IPR timeline on the slide, you can see a motion for joinder can come up to 7 months after the petition was originally filed. On top of that, the PTAB will issue a decision on whether or not to grant the joinder several months after the motion is filed. Earlier this year, myself and a couple other Brinks attorneys started to notice that some IPRs were missing their 1-year deadlines. My colleague Dan Parrish looked into this further and authored the Law 360 article, which is shown on the slide. That article describes 4 post-grant proceedings where the 1-year deadline for a final written decision was not met. And at that time, it was clear that the deadlines were being missed. However, most of the proceedings did not yet have a final written decision, so any information from the PTAB as to why that delay occurred or what the PTAB was saying about it, we just didn't have yet at that time. So as some additional time has passed, some more final written decisions in those proceedings have been issued. So we've looked at those cases from the article, and they're summarized on the chart on the slide. Looking particularly at the Mylan IPR, final written decision in that case was issued over 3 months late after the 1 year from the original institution date. And there was no discussion in that final written decision about any extension being acquired by the PTAB or asked for, and really no mention of the delay at all. Additionally, in that Mylan case, another interesting point, even though the joining parties agreed to adhere to the existing IPR schedule and that joinder would not affect the final written decision, we still saw this late final written decision. Next, if you can look at the PAR IPR, particularly the latest joinder column, this represents the last or latest date that the PTAB granted a joinder in those IPRs. And you'll notice for the other IPRs, the final written decision issued within 1 year of that latest joinder date. In particular, the Neptune IPR, it came out almost 1 year to the day. So an initial theory for what this delay entailed and how you could calculate when a final written decision would come out going forward was based on this latest joinder date, that it would be 1 year from the latest joinder. However, with this PAR IPR, you can see the latest joinder date was October 27th of 2016, and we're now into November of 2017, so we are beyond a year from that latest joinder date. So it appears that that may not be the new deadline going forward. Additionally, in the PAR IPR, in the PTAB's decision granting joinder in that case, the PTAB noted that the statute provided that the 1 year deadline for rendering a final written decision may be adjusted in the case of joinder. And that particular statute's 35 U.S.C. Section 316A11. Despite recognizing that, the PTAB then went on to state that they were hesitant to make this adjustment unless the joinder would unduly complicate the existing proceeding or cause lengthy delays. So despite acknowledging the delay and describing a hesitancy in PAR, the PTAB did go ahead and issue that final written, or will issue that final written decision later. In addition to following up on the 4 proceedings from Dan's article, we looked to see if there were any additional cases where delay had occurred, and discovered at least 15 more IPRs where the final written decision came more than 1 year after the institution date. Two to look at in particular are the Microsoft IPR, which appears to be the first IPR to show a delay in a final written decision, with that IPR being instituted all the way back in December of 2012. And the ZTE IPR, which still doesn't have a final written decision, but we are beyond the 1 year date from the date of institution. This October in that IPR, the PTAB filed a notice where they recognized that joinder had occurred and they had the statutory right to issue a final written decision later. And then the PTAB in that decision, or in that notice, went ahead and issued a new final written decision deadline for March 15th of 2018. So going forward, if joinder is going to continue to delay final written decisions, I think most, if not all parties, would prefer this openness from the PTAB of communicating with the parties and letting them know when the final written decision will occur, even if that is going to be after the 1 year date from the date of institution. In addition to looking at the IPR dockets, there's also been some communication from the higher-ups at the PTAB, particularly Deputy Chief Judge Bolick and Chief Judge Rushke. At the FCBA Bench and Bar Conference, the judges there confirmed that the PTAB was calculating its final written decision deadline based on the latest decision granting joinder. This was back in June 2017, and as we saw from the PAR IPR we talked about previously, this may no longer be the case, but this is what confirmation we had at that conference in June of 2017. So now that we know that delay is occurring, it's important to decide or determine if there may be ways to avoid that delay if that's not acceptable in a particular given situation. For petitioners, one strategy for avoiding delay is to solicit joinder from other parties as early as possible. Oftentimes, IPRs are accompanying a district court litigation, so a given petitioner probably has a good idea of who are the other defendants that they may need to contact. And the earlier that a motion for joinder comes in, likely the earlier you receive the decision from the PTAB, and less likely that your schedule can be affected going forward. Now, for both petitioners and patent owners, a strategy is to notify the board of joinder issues and have communication with the board of how delay may affect the parties in the case, and express the desire for delay to be as minimal as possible. If joinder has occurred early enough, you may be able to talk about the joinder delay issue with the board as early as your initial scheduling conference. If it takes place later, parties can always email the PTAB and request a teleconference to discuss the issue with the judges on the case. Additionally, the parties could propose agreed schedules that respect that joinder has occurred. So you may delay the final written decision a little bit in those cases, but at least you'll have the certainty of knowing what those dates are going forward. And also, parties can decide to file a motion with the PTAB requesting expedited review if you have a concern that delay will affect your case. But of course, the granting of that motion will be at the PTAB's discretion. And lastly, both patent owners and petitioners can oppose the motions for joinder to try and prevent the delay to occur. The PTAB considers several factors when deciding whether to grant joinder. Two in particular are probably most relevant, involving the delay of the final written decision. That would be whether there's discernible prejudice to either party, where if you're opposing joinder, you could talk about how the delay will affect your party. In addition, another factor is the undue delay of proceedings or related proceedings, where in the opposition you could discuss how the IPR deadlines may affect the concurrent district court that's going on. Perhaps the district court is stayed and waiting on a decision from the PTAB, and so you want to discuss that in your opposition. So that's all I have on the joinder issue at this time. I'll be ready to hop back in if there's any questions at the end, but now I'll pass things back over to Jason to introduce the next presenter.
Well, thank you very much, Josh. Just a little break right now for those of you who are who wish to apply for CLE. The first CLE code is printed on the current slide, and it is joinder.
Hello everyone, my name is David Bernard. I'm going to be discussing our second topic of the webinar. This is going to be about Article 3, standing to appeal PTAB decisions to the Federal Circuit. And so to jump right into some background, we first have to ask ourselves two questions to understand how standing to appeal PTAB decisions works. So the first question is who can file a petition for inter-parties review? Well, that answer is just as broad as it gets. It's anyone that is not the owner of the challenged patent. Then the second question is who can appeal to the Federal Circuit? Well, to appeal, you have to have standing under Article 3 of the Constitution, and this requires three separate things. One, that you have suffered an injury in fact. Two, that injury is fairly traceable to the challenged conduct of the appellee. And three, that the injury is likely to be redressed by a favorable judicial decision. So as I'm sure you've realized, Article 3 standing is more limited than what you would call standing to file a petition for inter-parties review. And so you can logically infer that not everyone who can file an inter-parties review petition will have standing to appeal a final written decision of the Federal Circuit. So then how do these two standards come into play in practice? Well, the Federal Circuit has addressed this issue a couple of times so far. First, in 2014, in the context of inter partes reexamination proceedings and Consumer Watchdog v. Wisconsin Alumni Research Foundation. So to give you a little bit of background on this case, Consumer Watchdog is a nonprofit organization, does not sell any products, and instead it engages in various activities that what it calls is for the public good. In this instance, Consumer Watchdog believed that it would be in the public interest to request inter partes reexamination of a patent because of Consumer Watchdog's concern that the patent was inhibiting scientific and medical research related to embryonic stem cells. So Consumer Watchdog was actually unsuccessful in getting the claims canceled and therefore appealed this decision to the Federal Circuit. And on appeal, the Federal Circuit questioned whether Consumer Watchdog actually had standing to appeal to an Article 3 court. And the Federal Circuit ended up finding that the Consumer Watchdog did not have standing. And in making this decision, the court focused on the first of the three standing requirements that I mentioned on the previous slide, whether there was an injury in fact. And in its brief, Consumer Watchdog actually only claimed one single injury, just that it did not obtain its desired outcome in the reexamination proceedings. The Federal Circuit found this unpersuasive, mostly because the reexamination statute merely permitted Consumer Watchdog to request and participate in the reexamination proceedings, and not to obtain any desired outcome. And so more recently, in January of this year, the Federal Circuit again considered standing, this time in the context of inter partes review. And so in Phygenics v. Immunogen, Phygenics filed an inter partes review petition challenging the validity of a pharmaceutical patent owned by Immunogen. Phygenics, to give you some background, was a non-practicing entity with an extensive pharmaceutical portfolio. And so the reason why they initially filed this inter partes review petition was because a third-party exclusive licensee of the challenge patent refused to license a similar patent owned by Phygenics. So Phygenics thought that getting rid of this patent would potentially increase the value of its own portfolio. Unfortunately for them, the PTAB found that the patent claims were valid, and so Phygenics appealed this decision to the Federal Circuit. Once again, the Federal Circuit found that Phygenics did not have standing to appeal, and they once again focused on the first of the three standing requirements, whether there was an injury in fact. Now, Phygenics did allege a bit more of an injury than Consumer Watchdog did. They actually argued that they had suffered actual economic harm because the challenge patent increases competition between itself and Immunogen, and therefore decreases the value of its own patent portfolio. However, the Federal Circuit said that this alleged harm was too speculative, and Phygenics just didn't provide enough evidence to support it. And thus, while in this instance, Phygenics did not have sufficient evidence to show Article 3 standing, the Federal Circuit does appear to have left the door open for non-practicing entities like Phygenics, assuming that they can provide concrete evidence and non-speculative evidence of an injury in fact. So where does this leave us? Well, I think it allows us to split petitioners into three categories. The first category is a petitioner who is involved in litigation over the challenge patent. And I think in this situation, there's no question that a petitioner here has Article 3 standing due to the potential injury of infringement allegations concerning the patent and the parallel proceedings. The second category is public interest groups, non-practicing entities, and those types of entities that challenge the validity of the patent. Generally, these groups will not have Article 3 standing unless they can provide some sufficient evidence of economic harm beyond just not obtaining the desired outcome of the IPR proceeding. The third category is, what about when a company challenges a competitor's patent without any underlying infringement litigation occurring? And this is a bit more of a question mark without any definitive answer at this point, and it's what I plan to focus on for the remainder of this presentation. So the Federal Circuit did provide some guidance in Consumer Watchdog and Phygenics. As you can see from these two quotes, the Federal Circuit distinguished Consumer Watchdog and Phygenics from situations where, for example, the appellant is engaged in an activity involving the subject matter of the challenge patent that could potentially form the basis for an infringement claim in the future, that the appellant is an actual or prospective licensee, or that the appellant plans to take actions in the future that would implicate the patent. So while the Federal Circuit doesn't come out and say it, it does suggest that direct competitors that are active in the same space as a challenge patent are likely to have Article 3 standing, even without any underlying infringement litigation. And so there is one instance in the context of inter partes reexamination where the Federal Circuit has addressed whether there was standing to appeal when there was no underlying infringement litigation, despite the fact that the appellant did actually compete in the industry. So in PPG Industries v. Valspar Sourcing, PPG was a manufacturer of beverage cans and requested inter partes reexamination of two of Valspar's patents related to the beverage can industry. So already, just by the virtue of competing in this industry, PPG has an advantage over Consumer Watchdog and Phygenics. And when PPG appealed the PTAB's decision finding the claims valid, Federal Circuit determined that PPG did have Article 3 standing. In particular, the court focused on two specific facts that showed a concrete injury sufficient to obtain Article 3 standing. First, PPG had launched a commercial product in the same technology area of the challenge patent that could give rise to a possible infringement allegation in the future. And second, PPG had received an inquiry from a customer that suggested that Valspar intended to pursue infringement litigation. The court said that this evidence at a minimum was sufficient to establish legitimate concern that PPG's activities would draw an infringement action by Valspar. So this case tells us that having some reasonable concern that infringement litigation may be pursued in the future, combined with activity in the same technology area as the patent, should be sufficient to establish Article 3 standing. I also just want to briefly switch gears here and mention a similar situation about what happens when the patentee appeals a final written decision. Can a non-practicing entity or any other party participate in the appeal when they wouldn't have standing under Article 3? Well, I'm not going to spend much time on this, but in sum, the court determined that even if a party would not have standing to file an appeal, it could still participate in the appeal, assuming the appellant, in this case the patent owner, has standing. And also one other note of importance here. The Federal Circuit confirmed that a patentee will always have standing to appeal a final written decision because an injury in fact occurs when a patentee's claims are canceled by the PTAB. This brings us to the question of what to do with this information going forward. Well, I think most importantly, in the majority of cases, nothing will change. Statistically, most inter partes review proceedings stem from an underlying patent infringement suit, where both parties will have standing to appeal. However, in these more uncommon situations where the inter partes review proceedings don't stem from an underlying infringement litigation, companies who are considering challenging competitor patents before an infringement suit is filed need to consider whether they would have sufficient support for standing if they need to appeal. Thus, they should be asking a few questions, such as the following. Has litigation been threatened or a license requested? Do you already or do you plan to sell a product in the same technology area as the patent? Has the patent owner sued other companies in the same technology area that might make you think you're next? Or is there a history of litigation between the companies or anything else that creates a fear of future litigation? Now, on the other side, a patent owner might want to consider attacking a petitioner standing on appeal. And another thing in that vein to keep in mind is that if you haven't already alleged patent infringement, you may want to consider that filing suit before the appeal is filed may give petitioners standing on appeal. Now, of course, there's other considerations when determining when to file an infringement suit, but this is something that you should consider just as a small piece of the bigger picture. Also remember that as a patent owner, you will not have any issues with standing on appeal if you do decide to appeal an IPR final written decision. And that's all I have for now, so I'm going to throw this back to Jason, but if you do have any questions, please send them our way, and we'll try to get to them all during our Q&A.
Thanks, Dave. And to that end, as a reminder, if you have any questions, please enter them in the Q&A section on your screen in the lower right-hand corner. Oops. All right. And here we have on the current slide CLE code word number 2, which is forward. Please take note of this so that you can apply for CLE later. All right, next up, I'd like to present to you Andrew McElligott, who will be presenting on the Federal Circuit's recent In Re Aqua case. Drew?
Thank you, Jason. Thank you for moderating today. Dave and Josh, thank you very much for your talks. Now that we've learned a little bit about joinder and a little bit about Article 3 standing, I'm sure everyone's wondering, what about motions to amend? I know it's on my mind. So as Jason said earlier, I'm here today to talk a little bit about In Re Aqua products, which is a recent decision from the Federal Circuit. Now this decision came down just a little over a month ago, but in that time it's been a very hot topic and the subject of a good deal of discussion and a good deal of speculation, given all of that, I presume that everyone listening has a certain level of familiarity already with the decision itself, but for those that do not, I'll provide a little bit of background here. So during an inter partes review, the patent owner can file a motion to amend some of the instituted claims, and in that way, attempt to correct what the petitioner is asserting makes the claims unpatentable. Prior to In Re Aqua, the Patent Office placed the burden of persuasion, the burden of proving the patentability of those amended claims over the prior art, on the patent owner. In Re Aqua, the Federal Circuit held that that was incorrect, and in the absence of a formally adopted rule to the contrary, the burden of persuasion should instead be on the petitioner. So what does this mean for motions to amend going forward? Well, the shorter answer is that nobody knows yet, not even the PTAB. One thing I'm sure many will be looking at in particular as we move forward is the success rate of motions to amend. When the patent owner carried the burden of persuasion, only 5% of motions to amend were actually granted or granted in part. We'll have to see whether or not that number changes or rises, as we haven't had any decisions yet in the wake of In Re Aqua. The most immediate and apparent effect that we've actually seen in our review of all the decisions that have cited In Re Aqua is the change and effect it's had on the briefing. So we're going to spend a little bit of time on that today. So the motion practice for a motion to amend is dictated in IPRs by 37 CFR 4224. And as this table shows, under that statute, the patent owner receives 25 pages for its motion to amend, which it previously had to use to prove both the proposed amended claims met the statutory requirements and could be entered into the proceeding, and also that they were patentable over the prior art and could therefore be entered into the patent itself. The petitioner then received a 25-page opposition and the patent owner a 12-page reply. This schedule and page allotment made sense when the patent owner carried both the burden of production and the burden of persuasion. But after In Re Aqua, petitioners are kind of left wondering, well, how can we be expected to shoulder this new burden, this burden of persuasion, without any additional space under the statute? While at the same time, patent owners are left wondering, what is it going to take to satisfy our burden of production? Now, that second point might not be as clear on its face, so I'm going to talk about that first. Because patent owners carried both the burden of production and the burden of persuasion in the past, there was no need to distinguish between the two. Now that the Federal Circuit has divided the burdens, we know that the patent owner still has the burden of production, but it's unclear what exactly that burden entails. What's listed here on the slide is most likely the bare minimum. We know the patent owner needs to at least satisfy this statutory criteria in order to get the amendments entered into the IPR, so that their patentability can even be considered. Beyond that, we've also seen the board reminding patent owners that they still have a duty of candor as well. So the board still also expects the patent owner to disclose at least any information or prior art that might be material to patentability. As of right now, I think we can safely say that this is the floor for what would be required to satisfy the burden of production. But we don't know yet what the ceiling could be. For example, it might not be enough for the patent owner to simply list off 40 or 50 patents that it considers material. The board may require the patent owner to provide some context or explanation as to why the patent owner thinks these references might be material. The second check mark on this slide, the amendment response to a ground of unpatentability involved in the trial, is another area where the board could ask for more from the patent owner and have them explain not only what ground the amendment responds to, but how the amendment rectifies unpatentability and is patentable over the cited prior art. So even in the absence of the burden of persuasion, the patent owner could still be required to present its position on patentability within its motion. The bottom line here being, we know the bare minimum that the board will require, but they've got a lot of wiggle room here within the current rules to require more from the patent owners to satisfy whatever they end up deeming the burden of production. Now, with respect to petitioners, as I said, the biggest issue so far has been a lack of space. And we've already seen many petitioners responding to this request, responding to this by requesting a surreply. The surreply provides not only additional pages to make their argument, but it also gives the petitioners the last word, which is typically what you would see for the party carrying the burden on an issue. The number of pages that we've seen in the surreplies has varied and appears to be based on the facts of each case, so it's dependent
on the facts and varies.
Some of these include
How many claims were amended, the extent of the amendments.
a bit more in the abstract.
It also involves how much the board thinks the petitioner will likely need in its SIR reply, given those first two factors and what the patent owner says in its reply. With respect to when to ask for a SIR reply, there doesn't appear to be any harm in raising that issue early, but from the cases that we reviewed, the board in some instances may deny those early requests as premature and ask the petitioner to renew the request after the patent owner has submitted its reply. Importantly, in all of the cases that we have reviewed, those petitioners that requested the SIR reply in view of In Re Aqua sooner or later had their requests granted by the board. Now, instead of waiting until the briefing has already commenced, the parties could request or propose a modified briefing schedule to the board during the conference call with the board preceding the motion to amend. This can be beneficial for both parties, with petitioners securing a SIR reply and some early certainty as to what the page limits of that SIR reply will be, and the patent owners potentially picking up some extra pages in their reply to respond to the petitioner's opposition. These two tables here demonstrate a few of the schedules that we've seen so far. In the table on the right, you can see that in at least one instance, the board entered a modified schedule that transferred 13 pages from the motion to amend to the patent owner's reply. And on its face, that makes some sense. You take the space the patent owner would have spent arguing patentability and transfer it to the reply so that later the patent owner has more room to rebut petitioner's arguments on patentability. However, patent owners should keep in mind, given what I just talked about earlier, the uncertainty with respect to the burden of production. Until that burden becomes more clearly defined, you may not want to negotiate away pages from that motion to amend. I also want to note that although both of these tables show patent owners receiving 25 pages for their reply, we've also seen other decisions where that's not the case, where both the reply and the SIR reply are limited to just 12 pages. So outside of SIR replies, we've seen other requests for additional space. And I just want to cover a few of those requests that we've gotten answers to and note their success rates thus far. So the first one here is, given the shift in burden, will the board authorize a 14,000-word opposition brief, which is basically the same size as the initial petition? This would increase the 25-page limit to somewhere closer to 70 pages. Not surprisingly, the board has denied these requests. They appear to be pretty resistant to moving beyond the 25-page limit, which is not to say that they won't allow that in the future when they're presented with a certain factual situation that requires it. They just haven't been persuaded yet. Number two, given the space limitations and the shift in burden, will the board waive the rule against incorporation by reference? Again, no, at least not yet. And given how staunchly opposed the board has been in the past to incorporation by reference, probably not anytime soon, but again, you never know what some future factual situation will present itself, and the board may be persuaded. And number three, instead of seeking to increase page limits or waive any rules, this one actually sought to split the briefing and deal with the patent owner's burden and the petitioner's burden separately. Given that there are two different burdens, why not have 2 rounds of briefing? So this third one asks, will the board authorize 2 rounds of briefing, with a first round directed to whether the patent owner has met the procedural requirements, and second, a round directed to patentability? Again, the answer is no, at least so far. Who knows what the default briefing schedule may look like in the future when the dust finally settles. They may consider this, but I think in this particular instance, when this was recommended, the timing just wouldn't have allowed for 2 rounds of briefing within the tight window they wanted to issue their written decision. So what happens next? Well, in its decision in Re Aqua, the Federal Circuit left the door open for the PTAB to potentially promulgate a new rule with formal notice and public comment. So if they so decided, rather than adjusting to this new division of burdens, the PTAB could promulgate a new rule and attempt to set everything back the way that it was. Now, I'm not going to say that the door was wide open, but it was open a bit. And the Federal Circuit certainly laid out some of the pitfalls and tripwires that
could be triggered should the PTAB choose to walk through this, and it would likely, any attempt to promulgate such a rule would likely be challenged. But the door was still open, at least ajar, and it's certainly a path that they could follow. Something else that some of you may recall is from a few months back, the PTAB announced its procedural reform initiative. It's been a couple of months since then, and we haven't heard a tremendous amount about it, but the former director of the PTAB spoke about it in May of this year and mentioned that the PTAB was reviewing the motion to amend procedures as well as part of this initiative. So there may have already been some wheels in motion behind the scenes to change procedures in the motion to amend process prior to in re Aqua. But again, we'll just have to wait and see until we hear something from the PTAB with respect to the direction it wants to head in. Which brings me to my third black box here on the slide, the chat with the chief. For those of you who haven't heard about this yet, the PTAB recently started its new webinar series, Chat with the Chief, and I presume everyone currently listening is huge fans of webinars, given your presence here today. I would recommend this one because it's an occasion where you can actually have a bit of a dialogue with Chief Judge Rushke and ask him questions on certain issues. They've already announced that the motion to amend will be a future topic that they will discuss. So that banning us hearing any formal guidelines prior to may be the first time we get to take the temperature of the PTAB on this issue. With that, that is all that I have, and I will throw it back over to Jason.
Okay. Thank you very much, Drew. Take a moment. The third CLE code word is displayed on the present slide, and it is waters. Please take note of this. And also I'd like to invite the participants that have questions to enter those questions in the lower right-hand Q&A, lower right-hand corner in the Q&A section, and we will take as many questions as we are able. All right. The first question I have is for Josh. Josh, can you please describe the circumstances in the biopharma or medical device context when a party may want to delay proceedings and when a party may not want to delay the issuance of the final written decision?
A situation where a party may be interested in delaying proceeding is if the district court case is completely stayed and you're the defendant in that case and have filed a petition in the IPR, you're probably pretty happy with the final written decision being delayed because that just gives you more time that you're not spending money in the district court, especially if you're already on the market and confident that you don't infringe or have an invalid patent. That's just kicking the can down the road. With respect to avoiding delay, oftentimes on the Hatch-Waxman side of things, where the district court is rarely staying its proceedings, delay can be a negative. It effectively becomes a race to the federal circuit between the district court decision on invalidity and any final written decisions on invalidity. And so I imagine oftentimes the petitioner probably feels like the chance at having a decision that would render a patent invalid is more likely in the PTAB with the lower burden of proof for invalidity. So in that case, a petitioner may be worried that delay may cause the district court decision to beat the PTAB to the appeals court, which would be a negative.
Okay, thank you. Next question I have is for David. David, do you have a sense of whether the post-grant review estoppel provisions might have an impact on whether a party has Article 3 standing?
Thanks, Jason. So, yeah, the courts in, I think it was a Consumer Watchdog and Phygenics actually did touch on this issue briefly. essentially, they said that for those instances where there is no risk of a future infringement action, which in both of those instances there wasn't because it didn't manufacture any products or practice in that field, the estoppel provision just doesn't have any practical effect on them. And therefore, there was no injury or harm to the parties because they wouldn't be the subject of any infringement litigation in the future. Unfortunately, the court in PPG did not discuss the effects of the estoppel provision when an actual competitor that actually may be subject to future infringement litigation is involved. And I think the court in Consumer Watchdog also left it open to future panels to actually determine whether the estoppel provision alone was sufficient to establish standing. However, in my opinion, I believe it should have a fairly strong effect in these situations. As estoppel provision not being able to assert those grounds in future litigation really is evidence of an injury in fact beyond just not getting a desired outcome in an IPR proceeding. Thus, in my opinion, the combination of a party being a direct competitor, which you would have to be for the estoppel provision to really matter, along with being stopped from raising those defenses in future litigation, would probably be enough to establish standing.
Great. Thanks very much, David. Next question's for Drew. Drew, you described a 2016 study that found 5% of motions to amend were granted or granted in part. Do you recall how many actual motions that 5% number reflects?
I recall it being very small, as I think it was 2 that were granted, and then it was 4 that were granted in part. And it's actually even smaller because the ones that were granted in part were basically just dismissing claims. They were just withdrawing claims. So it wasn't ones where you were actually substituting claims in and doing what we would consider a motion to amend in the context of the way we're talking about it today in Re Aqua. So you could probably even say it was smaller than 5% and just say 2 in the past have been granted, not percent, 2.
Right.
So it is something that a lot of people are going to be looking at, and I'm going to say one of the first articles I saw out right after Re Aqua was about what's going to happen to that success rate, because I think a lot of people are expecting it to rise, but there's a lot of others that are questioning whether or not this is going to have that much of an effect on the outcome, or just more of an effect on the procedures.
Okay. Right. And just a follow-up, I guess, do you have any thoughts on how high a burden that the PTAB is likely to apply, the burden of production that they're likely to apply in view of in Re Aqua? You discussed a floor and a ceiling. Just wondering if you could talk a little bit about your thoughts on what that ceiling might entail.
Well, I touched on a few of the things earlier that I thought could raise that ceiling. There's, in all honesty, so much gray area here when it comes to defining exactly what the burden of production is going to be, and they haven't had to do it in the past. So it's going to be new ground that they're going to tread here in terms of defining that burden. The only thing that we really know thus far, I think, is that floor. How high they want to make that ceiling, it could be incredibly high. It could be close to the burden that the patent owner carries now. It's just they'll define it differently.
Right. Okay, that's very interesting. A lot remains to be seen over time. Circling back, the next question I have is for Josh. Can you explain how a delay in the final written decision may impact patent owners and petitioners differently?
Yes. I think it's less to do about whether you're a patent owner or a petitioner and more to do with the situation that the case is in, kind of harking back to the earlier question we had. Obviously, petitioners, if there's a situation where you're racing to the Federal Circuit, petitioners are more likely to be on the side where they want the PTAB to get there first, just by the difference in burdens of proof between the PTAB and the district court. But with respect to delays affecting the district court schedule and maybe deciding when certain things happen, or judges waiting on certain decisions to issue from the PTAB, it could be either the petitioner or the patent owner who wants that decision to come out, perhaps just based on the facts of the case. Maybe one side or the other feels like they have a better case, and so they may want that decision to come out, or they may want that decision to postpone and let the other case go forward with different evidence.
Can I actually follow up on my answer that I just gave?
Well, of course, Drew.
So to bring everybody back to it, it was how high a ceiling it might be, what might be required of the patent owner. When I said that their burden could be roughly the burden that they have now, I don't mean to say that they'll still have the burden of persuasion. What I mean to say there is that kind of the motions that they'll have to go through may be equivalent to the motions they have to go through now. It's just going to be that the burden is on the petitioners to make the showing. It's really, or to prove unpatentability, but the patent owner will still have to go through the motions of saying, you know, here is why this is patentable, here is why this amendment makes this patentable over this piece of prior art for these reasons.
Yes, thanks for that clarification. Certainly, in view of in Ray, Aqua, the patent owner, is not going to carry the exact same burden.
Right.
I appreciate the distinction.
But the briefing may look a lot similar to what it has in the past.
Right, understood. Thanks. So I appreciate all the questions that are coming in. Keep them coming. I have another question for Josh. Briefly, in all but one of the cases that you discussed, the PTAB issued its final written decision within 1 year of the last joinder, with the exception being the PAR case. Do you have a sense of whether PAR is an outlier, or is it a harbinger of things to come in the future?
I think that's a really good question and an important one to watch going forward. I wouldn't be surprised if PAR is a harbinger going forward. The statute doesn't provide any requirements. It really says once joinder occurs, the PTAB is open to adjust the schedule, and there's no requirements of what adjust means. So you can effectively see joinder as an escape valve for the PTAB to get out from under the 1 year deadline requirement. And looking at what's going on with decisions in other areas of IPRs, what Drew talked about in Aqua with motions to amend just being a really good example. There's more and more things that the PTAB has to deal with, and deal with at a really intense level within that 1 year. Early on, motions to amend happened, the burden of proof was on the petitioner, very rarely granted, so perhaps the PTAB didn't have to spend as much time diving into those issues. And early on in IPRs, most of the patents were invalidated, and the final written decisions issued by the PTAB could kind of just quickly go through the issues that they were dealing with, and you could see the opinions were a little, have started short and grew as time has gone on, as remands from the Federal Circuit have kind of come in asking the PTAB to more completely explain the reasons for their decisions. And so I think all that pressure is weighing on the PTAB to spend a good amount of time making its decisions and writing those down in their opinions. And that pressure may lead them to want to use this escape valve more and more and extend the time they have to more adequately and intensely look at their decisions in these IPRs going forward.
Yeah, thanks very much. That's interesting potential outlook. I think we have time for probably one more question, and that question will go to David. You discussed the PPG case where the Federal Circuit found that petitioner had standing based on evidence that the petitioner was practicing in the same technology area, but also that petitioner had a legitimate concern that it could be sued on the patent. I was wondering if you had any thoughts on how that case might have been decided if the petitioner was practicing in the same technology area, but the evidence showed that the petitioner didn't have a legitimate basis for concern of being sued. For example, if the patent owner did not intend to sue on the patent, or there was clear non-infringement.
Thanks, Jason. So I think this is a good question, and it's one where we're getting into uncharted territory where we just really don't have much clear guidance from the Federal Circuit yet. In my opinion, I think that merely participating in the same technology area may be enough to establish Article 3 standing on an appeal from an inter partes review final written decision. And I say this for probably a couple of reasons. I think in the first instance, the court in PPG was looking for, the standard is, I think, a particularized concrete interest in the patentability of the subject matter of the patent. And I think that any direct competitor can show a particularized concrete interest, whether it's because of a current product of theirs out on the market that is similar to the patented subject matter, even if it's not infringing necessarily, or in light of the fact that invalidating a patent may free up some additional space in that technology area for future products or maybe changes to their current products. And I think a second reason would be that the Federal Circuit has indicated that the standard for Article 3 standing is somewhat relaxed when appealing from an administrative proceeding. In this vein, the Federal Circuit in the PPG case really didn't require much evidence of a real threat of future litigation. I think the only threat was PPG hearing from a single customer that Valspar may pursue infringement litigation. That's really not very strong threat, in my opinion. But according to the court, that was sufficient. And to me, that indicates that a real live threat of future litigation just really isn't necessary to establish standing appeal from an IPR final written decision. And instead, I guess the fact that they were direct competitors alone is really the important part and the deciding factor in this situation.
I see. Well, thank you very much. Well, we've come to the end of our webinar. I'd like to thank all of the presenters and thank the audience for your attention and for the great questions. If you have any questions, please feel free to contact me or any of the presenters. And feel free to check the Brinks, Gilson, and Leon website for updates. Thank you very much.
This concludes today's webinar. You may disconnect at any time.